scientific discoveries, it's important to make a distinction between discovering, say, a biological mechanism for how a chemical binds to its receptor. That wouldn't be patentable in itself. It might be a fantastic discovery and a brilliant bit of science, but there's no technical effect is the key thing. All you've discovered is how something is done. You haven't made the molecule that will influence how that works. That would be the patentable thing. So discoveries are excluded. Material that offends the public morals, that's also excluded from patent protection. I'm yet to find a good example of what this is. It's a strange one. It's in the Patent Act. However, cluster bombs have patents. Those are pretty morally offensive to me. All sorts of things that I will just term as adult novelties have patent protection. So I'm not sure what it is that's considered immoral, but it's in the Patent Act anyway. Presentation of information, just the way my slides look, for instance, not patentable. And also plant and animal varieties if they're naturally occurring. If, however, it's a transgenic wheat variety that's particularly resistant to insect attack or something, then you would be able to get a patent on that thing. It's only the natural ones you can't. Methods for playing games as well. People have tried in the past to patent the rules of how Monopoly is played, for instance. They're specifically excluded. And in the European Union, methods of medical treatment are excluded. In the US, however, you can get patent protection for this sort of thing. This would cover things like chemotherapy is a good example. So chemotherapy regimes, they can use multiple drugs administered at different times in different orders. In the US, you can get protection for the scheme in which you apply the drugs. In the EU, no. You could get a patent on the drug itself, but not the way it's used.